Hi, my name is Randy Pollak. I'm the managing attorney of the in-house legal department at Pacific Compensation Insurance Company. I'm also a certified specialist in workers' compensation law, and I'm the editor of the Workers' Compensation Quarterly, which is the official legal journal publication of the workers' compensation section of the CLA. I just said workers' compensation a lot, I understand that, but it's really important. Now, for some of you younger attorneys that are entering workers' compensation or have been in it for a little while, you may have found it to be a challenging, engaging area of practice of law that's quite rewarding. And I presented a legal topic that I think demonstrates that quite well on October 11, 2019, which is called Hot Topic Litigation and Emerging Trends in Workers' Compensation. I'll say that I've been in this practice now for approaching 10 years. I've found it very fulfilling and exciting and quite challenging and technical, which is something that not everybody realizes, and this presentation shows the technicality of it. The presentation was not a normal case law review, which can be, from time to time, feel like it's some things are quite irrelevant, marginal, they're just sort of hopping around from things that don't tell you a lot about workers' compensation. What I attempted to do with this presentation was to focus on little suites of areas of workers' compensation law that had been particularly challenging, and the Workers' Compensation Appeals Board had dealt with it with a series of decisions in the last year that gave guidance to the litigants. The first topic that I addressed was the apportionment amongst multiple dates of injury, and this is classically known as Benson Apportionment. And in the context is, if you may recall, that Benson addressed the idea of apportioning permanent disability amongst multiple dates of injury, that responsibility. And in that decision, they came up with an exception called, well, classically known as inextricably intertwined. It's not in that decision, but the concept of that is that the doctor cannot parcel out permanent disability amongst the multiple dates of injury. Yet the doctor's responsibility is to do that, and these doctors in that case, well, as that case was applied over the years, some doctors have said they cannot. And what does the board do with that? Well, in single specialty situations, such as just an orthopedic only injury, the board had said that the doctor couldn't do that, and that was their apportionment determination, and there's no apportionment, resulting in a combined award potentially to one injury. However, what's happened over the last couple of years, especially in the last year, there have been several decisions that have expounded on that, and in ways that were quite surprising. Specifically, there have been situations where 1, 2, maybe even 3 doctors, orthopedic, psych, internal doctors, have been able to apportion liability to separate injuries, yet perhaps a 4th or a 5th doctor could not. Maybe an internist, psych, dental, whatever. One doctor could not do it. What's the consequence? Well, the board found that you would do a combined award for all dates of injury onto one injury, despite the fact even if one of the reports or one of the specialists were able to do it based on substantial evidence. Well, that was a new evolution in this. The other topic that I addressed was the idea of adding impairment versus combining impairment. And this is a very substantial area of law that has developed over the last few years based on the Kite decision. The Kite decision found that you can rebut the combined values chart, which addresses multiple impairments, and the further you go up in the chart, the harder it is to get up in the numbers and results in a compression of the numbers. Whereas if you just added numbers, 25 plus 25 equals 50, versus under the combined values chart, it could be 25 and 25 equals 40 or whatever. It's much more substantial to be able to add them to get up into potential life pension awards or even 100% awards for the injured worker. Well, starting with that decision back with the Kite case, they had laid out they addressed a fact pattern that was pretty specific and that was, I guess, constraining the litigants over the next few years in their belief that that was what needed to be present to apply this thinking. And it involved a situation where bilateral extremities were involved. The injured worker had both arms or both hips or both knees injured, and the doctors found that to be resulting in a synergistic effect on the injured worker to where they needed to add the impairments versus use the combined values chart, which resulted in compression. Well, that's the status of the law for several years until the last couple of years, where the board has done a liberalization of how that law works. Specifically, they no longer require a bilateral extremities being involved. Specifically, they don't require the concept of synergistic. Rather, they focus more on the idea of, is it more accurate to add the impairments versus to combine them? And simply using that framework and applying it to asymmetrical body parts or ortho and psych and internal results in a different standard that is applied with the litigants. And what we've seen over the last year, especially with the explosion of litigation in this, as defense attorneys being caught off guard, applicants attorneys getting massive awards, especially when they get 100% awards, whereas before they may not even get life pension awards. So that was huge in the last year. The next topic I addressed was not necessarily the biggest topic in the world, but it was really interesting in terms of the evolution of the law and several decisions from the Workers' Comp Appeals Board, which was quite surprising. It's regarding the Labor Code 5402 presumption of compensability. The idea that if you do not accept or deny a claim, or specifically deny a claim, within 90 days of the claim, it becomes presumed compensable. And moreover, if you attempt to litigate that and rebut that presumption, you must show evidence that could not be discovered within the first 90 days with the exercise of due diligence. Well, that's a pretty hard thing to do. But what happened was that the court, analyzing prior decisions, specifically a decision that addressed the 6-month rule for site claims, had found that because the Labor Code spoke in terms of that defense, the 6-month bar to site claims, in terms of notwithstanding any other section of the Labor Code, this is a condition of compensation for the claim. They had construed that as an exception to that 90-day rule, meaning that you could use evidence that could be discovered plainly, easily in the 90 days as a basis to deny a claim and defeat it, even if you did not deny it within 90 days. Well, that was the law, but the board extended it to new avenues. Good faith personnel action defense, specifically. They had said that based on the same thinking of that case with the 6-month rule, because the Labor Code spoke in terms of notwithstanding in a condition of compensation, they extended it to that defense. That was a broadening of that exception and opens the question of whether there's any other areas of law that can be applied to that. The other topic I addressed was professional employer organizations, or PEOs. Massive explosion of litigation in the last year on this area of law. And simply put, a PEO is an outsourced HR department for a company. A company, perhaps a staffing agency, may want to focus more on that core function of their business and outsource the responsibilities of doing payroll, benefits, securing workers' compensation coverage. Well, in the last year, there had been a lot of litigation over instances where these PEOs disputed that they were supposed to get things like insurance coverage, disputed that they were an employer by contract and to get this insurance coverage, which resulted in quite a bit of litigation and finger pointing. Lots and lots of finger pointing in this year. And so what happened was the board came in with some guidance in this context as to whether a PEO is an employer, and if they're not an employer, what is their liability, if anything. And I went through the concept that what the board is doing is applying the classic general special analysis, general employer special employer analysis, which looks at whether there's control being exercised. A PEO, are they exercising control over the injured worker? And if they are, they can be considered an employer. However, there's a caveat. If they are not considered an employer, they may still have liability to the injured worker, or liability for the insurance aspect of it by contract. And if there is that potentiality, it could go to arbitration as the correct forum to resolve that. So the board, dealing with this new evolving issue, came up with that framework that they can be an employer, need to look for whether there's control, and beyond that, if there's no control and they're not an employer, can still find that they're responsible in arbitration under an insurance contract. The final topic I addressed, which is a rather technical topic, but very important given the severe consequences that can happen if you are not familiar on the law, is non-IBR medical legal litigation. And what this involves is plainly a provider submitting a bill for medical legal services that the defendant objects to on the grounds that the bill, for something other than the value of the bill. And what happens? What are the consequences of that? What does it trigger? And the board addressed several instances of this in the last year, but beyond that, I could tell you from my practice that this is a heavily litigated area based on the amount of activation of litigation in this area. Specifically, the rules here are very strict, that if a provider objects to an insurance company or an employer saying that I'm not going to pay this bill because there's maybe it's duplicative billing, it's not med legal, something else other than the value of the bill, it triggers a responsibility that if the provider then objects to that within 90 days of that bill, or that decision, that objection, that switches the burden to the defendant to file a DOR and a petition within 60 days. The consequences of that are quite severe, that result in a waiver of all arguments except for whether the billing is met legal, and results in potentially the employer paying not just the balance, but also sanctions, attorney's fees, costs, pretty much everything. And so I went through that point that that's a very hot area of litigation, and it's important to know the rules cold. I appreciate you watching this video. I hope that you all enjoy the practice of workers' compensation. And if you ever want to reach out to me, please, my email address is rpollak@pacificcomp.com, and I'd love to talk to you about workers' comp or submitting an article to the Workers' Comp Quarterly. Thank you.